So the final session before lunch is entitled The Increasing Role of Dispute Boards in the International Arena. It will cover the use and role of the dispute board, the FIDIC DAB, and the move to DAAB, the CERN 5-member panel of adjudicators, the dispute board as a dispute avoidance mechanism, and the World Bank's move towards dispute boards on all international projects. The chair of this session, although there are only 2 speakers in this slot, is Nicholas Gould. Nicholas is a partner in the specialist construction, engineering and energy lawyers firm Fenwick Elliott, where he conducts a mix of international dispute resolution and non-contentious work. He's a solicitor advocate, a chartered surveyor, accredited adjudicator and CEDA lead mediator. He is a FIDIC certified adjudicator sitting on international dispute boards and sits as arbitrator. He currently chairs the 5-member panel of adjudicators for CERN's expansion programme and is a DAB member of the ITER Fusion for Energy project in France. He's a visiting professor and co-lecturer with me at King's College London, vice president of the ICC Arbitration Commission, and is president-elect of the DRBF and past chairman of the Society of Construction Law. Quite how he finds time for personal time and all of that, I'm not too sure. Lindy Patterson, QC, is from 39 Essex Chambers. She is an international arbitrator, adjudicator and dispute board member, as well as an arbitrator within the UK. She operates across many jurisdictions, both civil and common law, and with a variety of governing laws. She has extensive experience acting as arbitrator, adjudicator and counsel. Importantly to this discussion, she is one of the world's foremost experts in dispute resolution boards. If you'd care to look at her profile on her website, there is a link and then a list as long as your arm of the dispute boards that she has been appointed to. Nicholas, if I could pass over to you.
Very good. Thank you very much, James. And hello, Lindy, and hello to everybody that's out there and has joined us for today. We've ended up just with 2 on this panel, but what we'd like to do is take you through some of the key issues that we think are important at the moment about the use of dispute boards. I think that they've been around certainly for a while now internationally, and adjudication in the UK has of course cut across the idea of having them here, I suppose, on major projects. That doesn't mean to say that you can't, but they are expanding internationally, and it is a really good way to resolve disputes quickly on major international projects, thus economically, and also though provides a dispute avoidance function. I think that probably with that very brief introduction we could almost start, but Lindy, do you want to say a few words as well before we get going on our debating topics?
Yeah, well, as you say, good afternoon everyone. This is the boutique session where there's only 2 of us, but Nicholas and I have both been on a number of dispute boards, and Nicholas is absolutely correct that I think they're on the increase, and we will discuss today why we think that is. They play an extremely important role, in my view, in the avoidance as well as resolution of disputes. And I wanted to ask Nick, really, first of all, what sort of contracts, in your experience, do you see dispute boards on?
Okay, thanks, Lindy. So FIDIC contracts is the obvious answer to that. Now, some of you out there will know about FIDIC contracts, you'll be familiar with them, but those of you some of you might not be. And I think that it's worth just a brief minute or 2 on the history to this. So FIDIC, the 1987 version, was pretty much like a typical English engineering contract. Engineers made decisions and that was that. And if you didn't like it, you went to arbitration. Then when they produced updated versions, I think the first one being an Orange book, a sort of design and build version, there was an option for a 56-day adjudication process. This seemed to work, and I was involved in projects where this was used, and then when we get to the 1999 version, suddenly they've put it in all of their contracts, red, yellow, silver. It's from the beginning of the project on red, and then on yellow and silver when there's a dispute. Now, we all agreed, I think, once once we got going on this process, that was a bit of a shame. You need your DB at the beginning, and this is the key point about dispute boards. You want them at the start to follow the project. Otherwise, you end up with a dispute perhaps late in the life of the project. I had one a few years ago. I was appointed on the dispute board to find that the project had already finished for a year. There was 700 days of delay, $56 million in dispute. Could we make a decision in 84 days? Well, yes, that's what you have to do. But what a shame. If you'd followed it from the beginning, you might have been able to help them avoid that, and you might have been able to bite off the disputes in smaller chunks. So that emphasis has remained with FIDIC, and in the new 2017, DAAB's dispute avoidance and adjudication boards are there very much in clause 21, and we're seeing them used more and more.
And in fact, they're now appearing in NEC4, which I think is another encouraging point. Option W3, there's an opportunity for dispute boards, and even in conjunction with adjudication, there's a practice note come out from the NEC. So I think they're on the move, but yeah, absolutely. FIDIC was the starting point. So I think that typically we describe the distinction, Nick, don't we, between the standing board, which is the board that's appointed at the beginning, and hopefully we'll get to know the parties, get to know the projects, and the ad hoc board, which is really the one that gets pulled in when there's a problem, often at the end of the project. What would you say the balance is in your experience between the two? How many might be more standing or more ad hoc?
Yeah, I mean, I think there's more ad hoc ones out there, and probably this is because the industry, not just the domestic industries in each country, but the international industry has moved towards design and build, hasn't it? I think there's a perception if you're an employer that your engineer designs it or your architect designs it and the contractor builds it. If there's any problems, there's going to be claims for time and money, therefore shift all the risk to the contractor. D&B is the way, and of course that's how we have just ended up with more ad hoc boards, I think, unfortunately, because that was what the yellow D&B book had in it. Mm-hmm. Is that your experience also?
It is, and I also wonder whether in fact it's affected by the regions that it's in, because my experience, for example, in some regions is that they have not yet understood this concept of having a dispute avoidance board. They still see them almost as a tick box at the end of the project, yes, sometimes as a stepping stone to arbitration. And I think it's going to take a while before they embrace it. For example, in Eastern Europe, I do a bit in Eastern Europe, I think you do too, and very much it's the ad hoc board that turns up there. Whereas in Africa, they seem to have really embraced this idea of having someone or three, as in fact it can be a one-person dispute board, but having them sitting alongside the projects. Is that your experience as well?
Yes, absolutely. And I think probably if you look at some of these regions where World Bank money or Development Bank money has been used, and you mentioned Eastern Europe, a good example, when they first start providing money, the Red Book might have been picked up, and they may well have had standing boards years ago. Then, of course, the shift to yellow has meant that the DB has been jettisoned if they were appointed at all. But when problems come along, that's when they start to get appointed. And but certainly on the projects where I have been acting for a party or advising a party to the contract, there's been a standing board, those projects have a much greater chance of success. And also, if you're advising a party where there are problems, you can say, well, don't send the whole thing to the dispute board, give them the first part, give them, is there a right to time in these circumstances rather than the whole claim? Because then it means that if they say yes or no, well, you can probably then negotiate the rest. Or if you send everything, they might get confused. I mean, I'm sure, Lindy, when you and I have sat on boards, we have 84 days, you get the referral, but you can't really assess it until you see the response. What does the other side say? And then you have to think hard about it. And okay, we're experienced in doing these things, and many DB members are able to act quickly. But compare that to an arbitration, which may go on for many years. I'm not sure the answers are any better, actually.
Nick,
there we are.
Nicholas, yes. let me bolster your boutique panel and or at least represent questions coming in from
Please
the
do,
delegates.
Yes.
one question from Edward Allbless is, who pays for the services of the standing board? Is it the parties or is it jointly? And I think there's another question to that, which is, isn't it the case that dispute resolution boards are really expensive and really only the domain of mega projects? Are dispute boards ever appropriate for smaller projects?
Well, will I maybe take that, Nick? I mean, I think, yes, they can be appropriate for smaller projects. Typically, they will be in what I would describe the longer running projects. So that's why I think you find them on infrastructure projects. I would say this anyway, but I don't think for a minute that they're expensive. There has been some research done, and to have a dispute board from beginning to end on, say, a 5-year project is less than 0.5% typically of the contract value. It is a very small amount. And just to give an example, the first nuclear project I was on a dispute board, it was 5 years it ran for. We did some disputes, we dealt with some disputes on the way through, but we were there at the beginning, we were there at the end, we had our photograph taken in the foundations, and then at the end. It was a fantastic experience, but they did not actually go to formal dispute. So it was worth every penny. But I agree, there is a perception of expense. As to who pays, it depends what the contract says. The contract will typically regulate that. Often it's half and half.
Yes, and just to add to that, that really both parties should be paying 50-50, shouldn't they? Because then it keeps this. No one thinks it's the contractors' dispute board because they're paying them. We've both got some money in this, and they're like not another consultant because that's not their role. But the amount it costs to have one person or three come along is very cheap on a big project. What about the smaller projects? Well, I had in Eastern Europe an employer there that had a whole series of projects that were between 5-7 million euros, this sort of range. What could they do? And what they ended up deciding to do was pool projects together. So they'd have 5 projects in a similar geographical area, one DB, one member appointed, and they made that person's name available at the very start. Any disputes about that will then put other names forward. But this one person then would come for a day's site visit or a couple of days site visit and just be taken between all of those projects. And then the cost was split between what would turn out to be 30-40 million euros worth of work. Even though there was the same employer and different contractors, or in some instances there might actually be a duality of contractor on some projects, that was felt to have a lot of utility. So I think it's just about thinking laterally about your projects. And the other thing today, of course, is it's much more easy now to say, how about virtual board, a virtual site visit will take you around the site by giving you a few PowerPoints and a few videos. I mean, I think you need to go once at the start, but after that it could be more economic. So we're now entering a new, perhaps quite exciting era.
And just on that, if I may, we've got a question from Julio that's getting a lot of likes and is relevant to the situation that we currently find ourselves in with coronavirus. He says, do you think ad hoc crisis dispute boards could be instrumental for the parties to deal with urgent and specific issues arising from the pandemic and the impact on construction projects?
I think definitely, and picking up on Nick's point, there's been more requests recently for dispute boards to deal with disputes, I would say, than for a while. There have been discussions about having site visits by drone. There's all sorts of things to get a handle on the site, but a dispute board is absolutely geared up to deal with disputes quickly and, I would suggest, cheaply.
Yes, absolutely. And I think we're going to see more of it. And just the other part about this is the economics. When we say I'll save the money on this project. I'm an employer. I don't want to spend the money on it. And over the next 5 years, I'm going to have 10 mega projects. Now, if on 2 of those, I have 2 colossal arbitrations, that's going to cost me 10-20 times more than all of the disputable costs put together. So you might say it's a bit of a gamble. There might have still be an arbitration anyway, but you can't know that. And in my experience, that the employers that that want to do this are more amenable, I suppose, at the moment. And I'd like to give a quick example, actually, if I could, and this relates to Caltrans. And I know that California's been in the news for these horrific fires recently, and this is what reminded me about them. But many years ago, maybe 20 years ago or so, of course, they had lots of work on this is the California Transport Authority, lots of work there, and lots of litigation, because, you know, construction, US system, quite contentious. They had disputes in their books with liability for 5 years, and they came across the DRBF, the Dispute Review Board Federation, and American organisation that promotes all this stuff, which is a great organisation. Look them up if you haven't seen them. And they started to introduce DRB, so early days dispute review boards, making non-binding recommendations. And what Caltrans did was put this on their projects, and they were actually impressed by it. And they said, we'll go along with the recommendation, even if we don't agree it, we'll go along with it. They started doing that. Then after a while, all the contractors learnt that they could have a dispute board, they'd resolve disputes. The employer would actually say, fair enough, we don't think that you're due the extra $10 million, but here's the money, we'll pay you. And then it became the point that more contractors wanted to bid with them. The prices got cheaper. And actually, those contractors that went on and litigated, they got taken out of the equation for future bidding. So now we're at a point now where they're having that their disputes are really dealt with during the project. Now, just think about that as an employer. You've got a 5-year massive project. You could have 5 years of liability arguing about the final account and claims, maybe an arbitration. They don't have that. So they've got their money available straight away to go to the next project without liability. Now, doesn't that make an awful lot of sense for governments, ministries of defence, transport authorities everywhere, it seems to me, that if you could just think about the economics in a different way, then, and you're enlightened, as it were, the contractors will go along with it, because they're probably always feeling that they're the ones that are due something. And it doesn't mean that they always are. If they're told they're not, well, you know, then maybe they just choose to carry on with an enlightened employer.
I wanted to say something about what makes a good dispute board, because that, of course, is fundamental. Nicholas, I mean, I don't know if you've been involved in ones where they've been all lawyers. That's never been my experience. The lawyers always tended to be the chair, because it's been fundamental to have appropriate disciplines dealing with the technical issues. But I just wanted to share this thought, which is actually it's less about the discipline and more about the approach, especially if it's a standing board, actually being open to try and bring parties together. Is that your view?
Completely. I don't think it matters whether they're a lawyer, architect, engineer, surveyor, whatever their background is, but they have to have sort of a mediation or conciliatory approach. They have to have an open listening approach and not jump to conclusions. Yeah. You know, we're not the engineer that's going to make a decision, or an arbitrator that's going to make a decision. It's about helping the parties to reflect on what they are doing on the one hand, isn't it? And at the same time asking them questions, because, and I'm sure that everybody listening has been in this situation, you're on a large project, it's late, you go to a progress meeting and you're the contractor, the employer, the engineer, there's no one externally there. And you talk about all sorts of things in the progress meeting, except for why you're late and what the problem is. And the project gets later because no one addresses it. When the dispute board's there, they're able to say, I noticed that you're out of, your program seems to be 6 months out. These structures over here haven't been built, what's going on here? And it gets the debate going. And it can become quite difficult because no one wanted to talk about it. But that, I think, is the skill that you bring to those difficult projects. And you can have lawyers that can't do that because they want to make decisions, engineers that want to re-engineer it because that's the way they've thought about it. And you have to rethink your skill set and be quite sort of open and listening and conciliatory, I think.
I think typically as well, there may be one party less keen on the board than the other. And I see one of the first roles of the dispute board is actually winning the confidence of both parties, that you're there for the project and not for one or other party.
Here's an interesting question, which I think follows on from your comments. It's from Robert Tustin. He says, is it ever tempting as a DAB member to give proactive advice to the parties that goes beyond the terms referred? The answer to that must be yes, but I suppose the follow-on question is, can or should you do it? And then he says, would it be viable for contracts to provide for the role of a third party on a project which has a more proactive general advisory role to the parties, where that third party can see things going off the rails?
Shall I go first, or do you want? Okay. Do you know, it's interesting because I think part of the thought process of being a DAB is actually the answer is no to that. Do you know, I know we all think we might know better, but imagine you're only going to site once every 3 months. I always feel to myself, if I see an obvious answer to something, I'm probably wrong, because I've missed all the past 3 months or the past year. And you know, it's about getting the parties to think about it and come up with their own solution. And I've been in situations where you have had discussions about perhaps what should happen next. They all agree on something sensible, then no one ever does it. Or they agree on something that I think is a bit odd, but they do that. And you know, the last thing you want is this third party disagreeing on or thinking that I know better about the method of doing whatever it might be. Because if I were to say, or our engineering function, if I'm sitting with some engineers, how to do it, and it turns out that it doesn't work very well, whose fault is it? It seems to me it has to come from the parties, and they have to decide themselves. Okay, if you were to go further and say, actually, we'd like a board that really can direct, aren't we really saying we don't really want a design and build contract, we want the traditional one with a really good engineer in there to do the job properly? You know, we're still getting caught between shift all responsibility and pay a very cheap price, but wanting a really good job and control. That's the real dilemma, I think. And the dispute board tries to keep it on track, tries to push it forward, but I don't think it should come up with ideas. You can steer parties, though, can't you, to ideas, and that I think is quite important. Sometimes it's possible by discussion, as you would in a mediation, to get the parties to come up with ideas and then themselves select what is the best one, and you feel quite comfortable with that. I don't know, Lindy, what do you think about all of that?
Yeah, no, I absolutely agree. It's going to create difficulties if you go to that length. As I see it, what we're there to do is to get parties to work together to get the solution. So all you can do is encourage in that respect. What I find useful about dispute board meetings is that if you get the right people coming to them, and that is actually quite fundamental, the people who can make a difference in the project, it is amazing how solutions can be developed. I mean, I have had tricky ones where directors from each party have arrived at a meeting and haven't spoken for 2 or 3 months. And that dispute board meeting is being used as a medium for exchanging views in a very helpful way. So actually, the mere existence of the board and the discipline of regular meetings with senior people can achieve so much.
Yeah. And just on that, just pausing for a moment there, I always think it's quite amusing that you find that on these large projects, sometimes they've not been communicating properly, but because we're there, they behave themselves. Yeah. And I find myself thinking, God, this is weird. They're grown-ups. Some of them have got degrees and professional qualification. I know it's not that, but the industry can be very culturally different and adversarial, and it's not helpful. But actually, sometimes when third parties turn up, they will behave themselves, and it gives you that chance to move things on. Just one last thing on this. I have been in situations where an engineering colleague on the dispute board has listened to something and thought they've missed the point. An example, you know, he said to them, well, had you thought about doing it that way, maybe, or that way? And that has led to situations where they've gone, yes, and we've just missed it because, and you know, you learn that extra bit of information, or they think, actually, no, we'll go and think about that. But it still becomes theirs, I think. But that's as far as you should go.
Yeah.
Interesting offshoot from that discussion. Question from Paul Caccioli. I hope I've pronounced that right. He says Network Rail and its supply chain have piloted and now developed a dispute avoidance panel, which are tasked with using the expertise of the panel members to identify potential disputes before they actually arise and form a dispute. Have either of you seen anything similar to that? And what are your thoughts on this sort of pure form of dispute avoidance as opposed to resolving disputes when they come to the board?
Yes, I mean, I've certainly seen examples of that with standing boards, because sometimes what will come up in the context of the meetings are issues which you can actually see coming down the line will be disputes if they're not dealt with. So you can guide parties to a discussion on that. TfL, Transport for London, of course, has its panel that is trying to do that sort of thing in quite a number of contracts as well. But I did know that Network Rail was leading the way in that respect. I think it's an excellent idea.
Yes, and I mean, I've been on boards where we've been standing, and by getting the parties to discuss things, we've come up with different methods, such as position papers from each of them, a telephone conference debate, they agree it and move on, or we actually give an opinion, a non-binding opinion on something, and that allows them to move forward. You know, these sorts of things do work and can be very helpful. And you know, I think also it's very helpful if the board has a sort of a workshop at the very start. If they're actually appointed early enough to have a workshop within the first 3 months to say, this is how it works and this is what we'd like to do, tell us about your project. Sometimes at that point, issues can be debated about, well, how detailed is your programme? Where is it? What are you going to do about part of the land that's not yet been procured, or whatever? It starts to get that early warning list together, I suppose. You don't often get it called that on these projects, but certainly in the London projects you would. And isn't that what this is all about? Here's a claim. If we go backwards, there were some issues that were going on here. If we go back before that, before it was a physical problem on site, it was obviously something in the paperwork or a problem or something that hadn't been entirely resolved. Can we start to forward think about that now? And this is where you get early warnings and so on coming from. But I think it's great to have external people who are pretty cheap, really, on the grand scale of things, to come in and help that thought process. Those people on the job have been involved in it so many years. They've looked at every problem, and, you know, and maybe they can't just see that one other thing. In the way that we ourselves, when you draft a document, you work on it 3 or 4 times, you still miss the last little typo, don't you? Because you don't see it. It's the same on the big projects.
Great. And another question from Neil. Lindy, if I can put this to you, what happens if a party doesn't comply with the DAB decision? What do you do then? How do you enforce that decision?
Well, as a dispute board member, obviously we don't do anything about it because it's between the parties and it's a contractual situation. What I found, interestingly enough, is I've done quite a few DRBs where all you're doing is providing a recommendation. And many people have said to me, well, what's the point of this? It's unenforceable. But it's fascinating how many parties will still comply with it. They may put in a notice saying they disagree with it, but in the meantime, they will go along with it. So there are provisions within the contracts as to how you enforce dispute board decisions as opposed to recommendations. Some countries, the jurisdiction or the courts are much more amenable to it than others. And for example, Eastern Europe, and many of the countries in Eastern Europe, that is a challenge, as is the case in some of the MENA countries. And I think all that we can do is continue to illustrate, I think, the benefits of these things. And I think more and more people will take them on board and comply, because it's all about getting the project done. It doesn't mean that they can't disagree with the decisions later, but it's about moving things forward.
Yes, completely. And I suppose that if you're acting for a party that's had some decisions and the other side is refusing to adhere to them, it can be a bit of fun and games. Can you go off to the local court and enforce it? Well, not really if you've got an arbitration clause. So you end up in this world of starting an arbitration, and do you ask the arbitrators for an immediate enforcement? Well, actually, you mean, can I have the damages and hold the money whilst the real issues are unravelled? And this is a bit more of a tricky situation. FIDIC in the 2017 has tried to deal with some of that and make it clear that you can adopt a summary approach using the ICC rules, for example. But yes, it's really about the buy-in at the start in the Caltran approach. So that, there is a long way to go, and that probably then I think means that we should just mention briefly the World Bank and maybe CERN. CERN is another organisation that's done this buy-in. They've got a panel of 5, and Lindy knows all about this project, and I'm the chair of the 5 there. So 5 of us follow what is in effect 4 contracts, and if a dispute were to arise, then 3 of us, one with the chair, depending on skill set, would drop onto that. And I think that's a great way to run these big complex projects. And then separately, the World Bank has said recently it really wants to try to get these dispute boards up and running on projects because it doesn't want to see long ongoing disputes afterwards. So now if the World Bank and other development banks that are putting money in say you will adhere, you will appoint a dispute board and you will adhere to their decisions, they can apply that economic pressure of making employers pay, if that's the way it is, in order to keep the cash flowing to that region. So I think that's probably where the real emphasis will come. Of course, in this, I'm sort of portraying the employer being the bad people who are not paying, but that is often what you see in some of these regions. But that's not to say that you don't have situations where the contractor has done a terrible job and there's a defect, and it's the other way around. But usually it's easier. If you've got a contractor from a developed country, it's easier to march off to the court in their country and get the money or call their bond. So the reality actually is in the developed part of the world is a bit more challenging. And some of this is authority and accountability. If you are, as I'm not going to mention countries, but if you are in charge of a governmental department and a project's $250 million and the claims 100 million or even 10 million or even a couple of million, if you sign it off, do you have the authority to really do that? Is someone going to say to you, well, what about accountability? And there's a real difficulty. So I can see why decisions are needed, and sometimes they're not paid and they're challenged.
Well, I must say, if I was the paying client, I would be sold by now on the idea of DRBs. But is there ever a situation when DRBs are not appropriate? It's a question from an anonymous participant.
Lindy, you're thinking, are you?
I am thinking.
Well, do you know, I suppose, well, maybe on those tiny projects that are spread around, perhaps it's not worth it. I don't know, but even then, I wouldn't agree, because I think if you have a dispute on a project that's not so big and you end up in arbitration, it's a real disaster. So I can't think that they wouldn't be useful in all situations, really.
Maybe. Maybe say you were 3 years out of the project. I mean, we do often have disputes that come after the project is complete, but usually it's about the final account stage, so it's still pretty live. But I guess 3, 4, 5 years after the project, if someone's dusting down disputes, you might be better simply then to go to arbitration. But I can't really think of another example.
Yeah, actually, no, you are completely right there. And there are situations which I've dealt with over the years where the limitation or the prescription period is about to run out, and they say we need to start arbitration. And you think, well, hang on, we need to go through the DAB first, because you can only start arbitration if you don't know the DAB's decision. So we better start pronto. And it's rather, it gets you into an odd situation, all of that. And so I suppose the reality actually is that to really be out there with it, I think that you should have your dispute appointed at the beginning to follow the job. That's the real benefit. And once you've finished, to put them as simply a process between that and arbitration after the event probably is not really economically worthwhile or helpful.
Very good. Let me.
What about the future of dispute boards? I'm looking at the questions here, but I'm looking at the time too. But I was just wondering, Lindy, what you think about the future for dispute boards now, especially given sort of COVID and all these changes and the fact it has been increasing in use.
Yeah. I think we're going to see more, and actually, I mean, I would say that I have already seen more requests to constitute boards, and it's a combination of cost. Well, it's cost principally, but I think, interestingly enough, an understanding that it can be done remotely. I mean, we've had quite a few discussions about how you do the site visit, but there's been an amazing number of suggestions, and I'm giving an example of a drone because that's one that I am involved in at the moment. But there's been a real desire to constitute dispute boards now, and it may be cost driven because of what's happening.
Yeah, no, and I think that's very true. Is that COVID has probably impacted most nearly every job in every country, which is a very odd situation. Sometimes you have something in a particular country or region, you don't see it anywhere else, but it's happening everywhere. And then also we can't travel. And I have done dispute board virtual dispute board meetings recently, and they seem to work incredibly well. We haven't done a drone flyover yet, but that has been discussed. But for example, if the contractor and engineer prepare PowerPoints with photos and explanations, you know, you've been to site once, you really get it. The other great thing about these sort of Zoom or team meetings is that they make their points, you've got a record of it, and everyone sticks to time and no one speaks over the top of each other. You know, in meetings they get excited, but actually here it doesn't work, you all stop. So I think it's quite a nice discipline, and certainly on these ones that I've done, both the contractor and the employer have seen that the fact that it's just much cheaper, and actually I think they want to stay doing this. So I think we will see more of them, and with the World Bank pushing for it, you know, there is a new way. We don't have to fly to the other side of the world now and all of this stuff. We can maybe do that once on the project, and then after that we can have a regular update. And it's easy if they suddenly want to talk to you in a few weeks, you can have a couple of hour call about a particular issue. This is the modern way, isn't it? But we've all been missing. It's been there, but we've not been brave enough to do it.
Okay, are we about out of time, James?
I think you are. It remains for me to thank you, Lindy, and you, Nicholas, for a really intriguing session. Dispute resolution boards, to many, are misunderstood, and I think not only have you clarified certain aspects of dispute resolution boards, but persuaded, no doubt, scores of clients who are dialing in to consider dispute resolution boards in their contracts. So, thank you very much, both.